Is Emily Neumann, managing partner of Reddy Neumann PC, and with me today is Rebecca Chen. She's also one of the lead attorneys here at Reddy Neumann and a partner as well. She files all kinds of immigration applications, got tons of experience, so glad to have her with us today. Topics for today, we're going to be talking about the latest on the H-1B lottery. You're probably aware that USCIS did conduct a second round, so we'll give you the updates on what's going on with that. We also wanted to talk about this idea of making the filing date current in the October visa bulletin. What are the pros and cons of that? Is that something that's possible to do? And now that we have H-1B selections again for people that were not selected, they may be considering what other options they have. And one of those may be to obtain an H-1B with a Cap-Exempt employer. So we wanted to go through what are the requirements of these companies, how do you find them, so that you can potentially still receive an H-1B and continue your work authorization, but through a Cap-Exempt employer. And lastly, we want to talk about issues that come up with I-94s, particularly at the port of entry when you're coming into the U.S. Sometimes they give you the wrong end date, sometimes they give you the wrong class of admission. Sometimes your I-94 doesn't even show up. And so what are your options to get those issues corrected depending on when you notice the error that's happening? So starting off with the H-1B lottery. So Rebecca, kind of what did USCIS announce last week? What did they announce yesterday? Where are we at with all of that?
Yeah, so last Thursday, USCIS made an announcement that there would be a second round of selections from this year's lottery. That was the first time that we had some advance notice. In previous years, when there was a second round of selections, we would just get the email that there was an update to the My USCIS account, but they did provide some notice last Thursday. And then for our office, at least, we started seeing selection notices uploaded to the My USCIS accounts, I think starting late Friday and then into Saturday. It looked like they had kind of tapered off, I would say, by Sunday. And then the end of day yesterday, USCIS confirmed that they had completed uploading any selection notices that would be coming through in this second round. So as of now, if you have not received a selection notice in the second round, unfortunately, it looks like you were not selected this time around. It doesn't necessarily mean that you aren't selected this year, which we can touch on a bit later. But as for the selection notices for this most recent round, they look very similar to the first round of selections, and they specify that the filing window for the H-1B petitions is August 2nd through October 31st. So October 31st is the deadline for H-1B applications to be submitted for this, anyone selected in this second round. If you are on an OPT and you have an EAD that is expiring this summer or already expired, for a lot of reasons, you'll want your employer to actually file the application and probably do premium processing to try to get it approved by October 1st so that your H-1B status can go into effect as soon as possible. So even though you have until October 31st to file, for people who have OPT EAD that expired or is expiring before September 30th, you'll actually want to get your application filed sooner and probably in premium processing so that your H-1B status can start October 1st as soon as possible. USCIS also released some statistics for the total number of selections. And Emily, I know you and our partner Stephen Brown did some math to kind of figure out, based on those numbers, what it meant for how many people were possibly selected in that first round in March who ended up not filing. What were we able to find out based on that?
Yeah, so we kind of did some rough math here, and we're attorneys, so math is probably not our strong suit. So hopefully this makes sense. But we know that there are 85,000 slots, and in the first round, they selected 110,000 registrations. So there were 25,000 extra that they selected because they knew a certain percentage weren't going to file or would be denied or would be withdrawn. So ultimately, it was about 30% extra that they selected the first round. Now we also know in the second round that they selected another 77,600 registration. So almost enough to fill a whole cap just in the second round by itself. So we kind of are thinking, okay, if they selected 30% extra again, that would mean, let's see here, about 20,000 approximately extra would be selected this time around, leaving us to say there's about 55,000 slots still open. So with all of our bad math, what Stephen and I came up with is we're thinking that after the first round, only about 30,000 genuine petitions were actually filed from those 110,000 selections, which kind of makes sense because we were talking about if, we had 780,000 people registered, and USCIS already came out and said, well, 400,000 of those are duplicates. That's about 60%. Yeah. So assuming 60% of the 110,000 registrations were duplicates, only 40% actually filed, those numbers kind of make sense. So because even though they selected another 77,000, if they needed that many, we might even see another lottery, because I think we're, from what we're hearing, people are, calling into our daily conference call and setting up consultations saying, hey, I was selected this time around, but I also had done duplicate, multiple employers submit my registration. Should I file? And we're still telling people in that situation, unless they're legitimate multiple job offers, that you should not be filing in that situation, even if you got selected this time around. So we still may be seeing that we're short, and that happened the first year in 2020 as well. Now, so how did in our office, our selection rate change from the initial registration up till now that we've got all these new selections? Did we see that many more selected this time?
Yeah, compared to previous years where there were second and even third rounds of selections, I would say in the past, a second round of selections was much smaller than the first round of selections. That was not really the case this year. We saw a pretty substantial number of selections for a second round this year, which kind of fits in with the, with what you were talking about with the number of new selections that had to happen and to get USCIS to the number they needed. So it actually increased, I think in our office, our selection rate in March was at around 16%. Our selection rate overall, including March and this most recent round, is now at about 22%. So it definitely was a good increase in the selection rate, but it's still below kind of the selection rates that we have seen in the past, especially earlier years of the registration system where there was more likely to not be these multiple registrations. And so that's also why we're thinking that there could be a third round if a significant number of these second selections also do not result in an H-1B petition being filed.
All right. And I think also on our Twitter, Stephen had also shared about our recent Freedom of Information Act request. Several weeks ago, he had submitted a FOIA request to get some additional information about these registrations in the lottery. And so we actually got a response on that on a CD-ROM, which nobody has anymore, but we have a special one just for our FOIAs here in the office. And so, one of the things that we had asked for was a list of all the companies that had registered people and the number of registrations. And it's a very long list, but there are some companies that you've never heard of before that, looking on My Visa Jobs or the USCIS H1B Data Hub, they've maybe filed less than 50 H1Bs ever. And this one company, I'm not going to name names here, but They submitted 2,200 registrations, one company that is clearly not they don't have 2,200 job offers. Another one, 1,600, another one, 1,400, another one, 1,400. I mean, I can just tell from not just from the names of the companies, but we were able to look up some of their filing history, and these companies have never filed before, and all of a sudden they're filing 1,200 registrations. So that's been very eye-opening to just see how the extent to these duplicates. It's just mind-boggling that people think that was okay to do. Now, USCIS says that they've got a regulation coming that's supposed to bolster the the protections in the registration system and try to reduce some of this fraud. But as of now, that regulation is not scheduled to be proposed until like December of this year, which means it's very unlikely that it's going to be finalized by next March 2024, when the next lottery registration process will happen. So I'm a bit skeptical of this whole process, given how bad it is in these duplicates. Hopefully we'll see some criminal action from it. I don't know. I think USCIS again reiterated that they are referring people to law enforcement when they can, and they're definitely, we know for sure they're issuing notice of intent to deny, notice of intent to revoke still for prior year registrations where we saw these duplicates. I don't think we've seen any yet for this year's filings. I think they're probably still gathering evidence and waiting to see how many companies are going to go ahead with their duplicate filings, even knowing that they colluded with other companies. So that remains to be seen, but definitely there's still risk for those people that did do the multiple filings. We definitely would say talk to an immigration attorney before you proceed with that to make sure you're not setting yourself up to fail. Okay, so moving on to our next topic. So we have Congressman Raja Krishnamurthy and another Congressman Larry Bouchon, who got a group of congressmen to sign a bipartisan letter to both State Department and Homeland Security about possibly making some adjustments in the way they do the October visa bulletin and making the filing date chart current every October is what they're urging the Biden administration to do. Basically, we know October 1st is next year's fiscal year starts, and there are 140,000 employment-based green cards that become available on October 1st. And the argument is, well, none of those visas have been allocated yet, which means they're all available on October 1st. So if they're all available, then we could say that there are green cards immediately available for people who have an approved I-140. Therefore, we should allow them to file the adjustment of status. So basically they're saying make the filing date chart current for everyone to allow anyone who has an approved I-140 to file in the month of October every year. Now, certainly there are a lot of advantages to applicants doing that. They'll get, the EAD, they'll get the AP, they'll have the AC-21 job portability, definitely a lot of pros to that. But at the same time, it doesn't speed up the time people will get the green card. So it's a Band-Aid. It's not solving the problem for anyone. It's just making things a little bit better. Do you think that the Biden administration could do that? Does it make sense for them to do that?
I mean, anything that brings more attention to kind of the high-skilled visa holder backlog with the green cards is always good. But for a lot of practical reasons, we don't really see USCIS and the Biden administration doing this exactly, making everything current in October. There are over 700,000 employment-based applications we know that are in the pipeline. And we just don't see the agency opening itself up to accept all those applications in a single month. It was hard enough for them to deal with the applications that came in October 2020 when that was just a forward movement in priority dates by, a certain number of years, not even making everything current at that time. On top of that, as you said, it doesn't result in any faster issuance of green cards because it doesn't increase the number of green cards that are available. And so it would just result in hundreds of thousands of pending I-485 applications with EAD and AP benefits that the agency has to keep renewing indefinitely for decades if there isn't a more permanent fix that comes through in policy or through Congress. It doesn't sound like something that the agency is going to take on just because of those kind of practical concerns, but we are glad that there is more attention from Congress on, the high-skilled visa holders and the green card backlog there. It definitely requires more attention from Congress and the Biden administration, but there are better solutions, in our opinion, that the administration could easily implement that would not be that far off from different measures that they've done in the past. And so some of those we've spoken about before. If the agency stopped counting dependents as toward the employment-based green card quota, that would itself on its own do a lot to move the priority dates forward significantly and improve the backlog in a way that wouldn't make everything current right away, but would, move people along the pipeline in a much more reasonable manner. Another thing that they could do is just issue the EAD and AP to anyone who has an I-140 approval. They've been just issuing benefits to immigrant visa petition beneficiaries on the family-based side. We've seen they've been setting up a parole system for I-130 beneficiaries from certain countries. That never existed before. That's a benefit that they're just giving to I-130 approved beneficiaries that they could, do for I-140 approved beneficiaries in the form of an EAD AP that would confer kind of the same effects without the problems that might come from making everything current all at once that probably the agency wouldn't be able to handle.
Yeah, and I know, obviously if they do agree to do this, they're going to get tons of revenue from the filing fee for the I-485 application, which they claim they need revenue. They don't make enough money off from the filing fees to cover the costs of adjudicating all these applications and things. So that's definitely a positive. If we're allowing so many people to file, it will generate more revenue that the agency can use. At the same time, the agency would then be binding themselves into renewing EADs and APs without any additional fees for decades. Because, as we know, with the current filing fee system, you pay a certain amount for the I-485 and the EAD and AP is included along with that with no additional filing fee. And all the people that have been renewing their EAD APs since that rule came into place in 2007, they're getting those free. I mean, unless there's a legal fee, of course, but filing fee is zero for those. So this agency is having to do work for free every year or every 2 years for people that have the pending 485. So I don't know how willing they're going to be to do that. They are planning on adjusting the filing fees. We're expecting that to come out, I think, in March 2024. And I think part of that was to go back to the old way of having separate fees for the 485, 765, and 131. But when they made that change back in 2007, they didn't make it retroactive to 485s that were already filed. It was just going forward. Anyone who filed a 485 after that particular date didn't have to pay the extra fee. So assuming they do the same thing, it would be when we increase the fees next March, anyone who files a 485 after March would pay a certain fee for the 485, and then they'd add the fee for the 765 and 131, and those people would have to keep paying the renewal fees. What about everybody who files in October 2023 Are they going to be willing to take on that expense of renewing these indefinitely without any fee payment? I don't know. Now, please, people, don't think we're against this. I would love to see everybody who has an approved I-140 be able to file the 485 and get the E80 and AP and be able to travel without a visa and be able to work without having to deal with H-1B renewals and all those sorts of things, and be able to utilize AC-21. So we're just coming at this from a practical standpoint. Is this something USCIS could do given the current environment? Would it be smart for them to do that? And is it overall fixing what needs to be fixed, which is increase the cap, get rid of the 7% per country limit? There's more foundational problems, which I know we can't address without Congress, and that's obviously not happening anytime soon. So please don't think we're going and trying to tell USCIS don't do this. We're not. Happy if it happens, but I'm just caution on why they might not decide to go with that plan. All right, coming up next, we wanted to talk about what makes a company a cap-exempt employer. And so that they, if they're cap-exempt, that means the person they're filing for does not have to go through the lottery. They can file any time of year. They don't have to worry about this October 1st start date and this 20% chance of selection and all of that. So, a lot of people equate cap-exempt with nonprofit. So is it that any nonprofit can be cap-exempt and file H-1Bs without going through the lottery, or are there certain requirements for that?
Yeah, there are very specific definitions of cap-exempt employers for H-1B purposes, and it's not all nonprofits. So it's a petitioner that is an institution of higher education, so colleges and universities, petitioners that are nonprofit entities related or affiliated with higher education institutions. So kind of the classic example of that is like a hospital that is affiliated with a medical school or a university, or a petitioner that is a nonprofit research organization or a governmental research organization. So if the employer is not a university or associated with a university, but they are nonprofit, the only way they qualify as a cap-exempt organization is if they are a research organization, which USCIS has said in the past, one of their primary missions has to be research. It doesn't mean they can't do anything else, but one of their primary functions has to be research, and they have to be nonprofit in order to meet the definition of a cap-exempt organization. So it's not any nonprofit, but those are kind of the main definitions of a cap-exempt organization. In addition, there are a couple of exceptions. So there is a provision that says that an employer that normally would need to go through the lottery, a cap subject employer, it could potentially file for an employee as cap exempt if that employee will be placed at an organization that is considered cap exempt. So if the employee will be working at a university or college, but the employer is a for-profit organization, like a for-profit company, like a consulting company, or in the example of physicians that USCIS looks at a lot is physician groups, private physician groups that are the actual employers. The ones issuing the W-2s are private, employers, but the employees are being employed at a cap-exempt organization, like a teaching hospital or a university or a nonprofit research organization. That is an exception where the for-profit employer is not subject to the lottery. They can file for that employee at any time. There's also an exception to where if an employee is working for a cap-exempt company on an H-1B, hasn't been selected in the lottery, they can work concurrently for a cap subject employer, that cap subject employer would just file a concurrent H-1B petition. And as long as the beneficiary is able to carry out the duties of both jobs with the cap subject employer and the cap exempt employer, that is kind of another slight loophole or a way for a cap subject employer to file an H-1B for an employee without requiring them to be selected in the lottery.
As far as you know, is there any list of cap exempt employers out there anywhere?
No, unfortunately, yeah, we do get that question. There isn't a published list, although I believe the first time an organization applies outside of the cap, of course, there is kind of more scrutiny by USCIS. Once they have been sort of approved as a cap exempt organization or sort of certified, it's much easier for them to file afterwards. So usually if you ask a company if they have filed cap exempt H-1B petitions in the past, that is a pretty good indication of, whether they are cap exempt. And if they're not, it doesn't mean that they can't, but you would just need to probably work with an immigration attorney to ensure that they meet the definition of cap exempt.
All right, I think we can move on to I-94 issues. If there's a problem with your I-94, what are the different ways that you can correct an error? Which ways work better than others? So, for example, let's say this happened to one of my clients not too long ago. He was on H-1B and we were getting ready to file an H-1B transfer to a new employer. While we were preparing the paperwork, he had traveled to Canada and back into the US. And when we got his I-94, it said he entered on B1, even though he came in on his H-1B visa. So clearly that was an error from CBP based on the class of admission. It should have been H-1B. We're about ready to file a transfer, but it looks on paper like he is not in H-1B status. He's in B status. So in that situation, what's one way that this person could get that I-94 corrected?
Yeah, the standard way is for them to go to a CBP deferred inspection office, and there is a published list on the CBP website of their deferred inspection offices around the country. Each deferred inspection office has kind of their own rules for how they want to be approached for an I-94 correction. If they have an in-person option, then they usually have specific hours that people can visit the office for a correction. A lot of the offices now have an email address that the visa holder can contact, and a lot of times the I-94 correction can be done without an in-person visit, which is very helpful.
Now, if the airport that I entered in that made the mistake doesn't have an email address, do I have to go in person to their location, or can I email any of the other deferred inspection offices that do have an email address?
Yeah, it seems like you can email a CBP office that was not the port of entry that you actually entered in to get the I-94 corrected. And we have had some clients do that successfully. So if the port of entry that you entered from on their deferred inspection office website does not have an email contact option, you can look for another office that does have an email contact option. Try emailing them to see if they will do the correction. And a lot of times they will.
Yeah, because these, when you go into the CBP office, I mean, it's, sometimes it's not a pleasant experience. A lot of times it's not a pleasant experience, even if you've done nothing wrong. And it's clearly their error. They just are not that helpful or friendly. So if you can email, that's the best way to do it. But there are some situations where email may not work. So what about a case where you're entering into the U.S. and they shorten your I-94 end date because your passport is expiring before your I-797 approval is expiring? Let's say that you notice it after you enter and you've gotten your new passport. Can you still use the email address to get that kind of correction?
Unfortunately not. From CBP's perspective, they don't view that as an error because it's kind of their policy that if you're entering with a passport validity that is shorter than your I-797 validity, that's just their policy to issue you the I-94 as far as your passport is valid instead of your I-797 approval notice. So from their perspective, they don't view that as officer error, and they won't extend your I-94 through the deferred inspection office. Unfortunately, in that situation, you basically need to consider that your status in the U.S. is only valid to that shortened date on the I-94, and make sure before that date to either have your company file an extension application on your behalf, or that you depart the U.S. before that date and re-enter with your renewed passport in order to get the longer I-94 validity.
Yeah, and it's super important to notice these things before the I-94 expires. It becomes much more difficult to correct it after your I-94 already expired, because CBP and oftentimes USCIS take the opinion that you're now overstaying. Even if you have a valid petition that had another I-94 on it that's not expired, the last action was your most recent entry where you got the shorter I-94, and they have taken that stance that if you stayed beyond that date, you're not only out of status, but accruing unlawful presence. And you want to make sure when unlawful presence is involved that you never exceed 180 days of unlawful presence, because if you have that and then you travel to try to fix the error, you may be triggering a 3-year bar to being able to come back and need a waiver and all those sorts of things. So definitely want to avoid that. So best practice is every single time you enter the US, as soon as you can, look up your I-94 on that CBP website, print it out, make sure there are no errors, verify that you have the correct end date. And if it is shorter, figure out, is it an error or is it because my passport was expiring, and make sure you take action before that I-94 expires, not after. All right, I think, are we good to go to questions?
Yep. Let's see, there's a question from Srikar about automatic revalidation, whether he needs to bring the expired visa if it's in an old passport, or can he just use the I-797 with the I-94 attachment to do automatic revalidation. So you do need to show the expired visa stamp. Even if it's in an old passport, that's not a problem. Just carry both passports, your old passport with the expired visa stamp and your current passport plus your I-797 with the I-94 attachment. And with all those three, you can automatically revalidate.
Karthik says, what will be the change of status date for people selected in the second lottery? So if I recall, the last time we had multiple lotteries, we still had to put October 1st as the start date, right?
Yes.
Even if we were filing by the October 31st deadline.
Mm-hmm.
So you'll still list October 1st. So if you're filing between now and September 30th, your start date would be October 1st, assuming that the change of status is approved by then. Otherwise, it will be the date of the H-1B approval if the approval happens after October 1st. But we still list October 1st as the requested start date, even if you're filing October 31st, which is the deadline.
Kieran is asking, he's filing his H-1B extension in premium processing, and if his spouse concurrently files the H-4 and EAD, will they be approved altogether? Yes. Ever since the litigation settlement, USCIS has agreed to go back to concurrent processing of all three of those applications if they are filed together, and that went into effect earlier this year. In practice, I think for the most part, we're seeing that happening. All three are being approved pretty much at the same time. Here and there, maybe there are some where the H-4 is pending longer, but it's pretty rare. So I would expect that all three will be approved at the same time.
KC has an H-4 visa stamp that was expired in 2017. and wants to know if they're still eligible for Dropbox if traveling in December 2023, since it's been more than 4 years since that visa stamp expired. So yes, as of now, the rule still is if you've ever had a visa before, you are eligible for Dropbox if the system allows you to select that as you're going through and answering the questions. That is expected or is scheduled to go back to ever having a visa within the last 4 years in December. So we don't know if that's going to be extended to where we can continue to get visa Dropbox based on any visa in the past, not within a certain number of years. That could be extended further, but we probably wouldn't know that until December.
There's a question about AC-21 changing jobs and how much can they differ from the I-140 petitions sponsored position. So it just needs to be a same or similar occupation. And if it is, then after 180 days from the I-45 being filed, you're eligible to change employers multiple times as long as the occupation is same or similar to the one described in your approved I-140 petition. USCIS has been pretty broad in interpreting same or similar. So as long as it is basically in the same field that was described in your approved I-140 petition, I would say it will meet the same or similar definition. If you have moved into, if you were initially approved as a systems analyst and now you're a project lead or even a manager for, a computer occupations, and those reporting to you are systems analysts, if there's been a progression and you're just in a higher level version of the job that you were approved for on your I-140, that is fine. Even, a slightly different version within the computer occupations field. Generally, if your new occupation has the same on the SOC code, if it still starts with the same two numbers as the one described in your I-140 petition, that's a pretty good indication that it's same or similar. It mostly prevents a complete change in field to, a completely different profession. But generally, if you're still using the degrees that you used before, it will be considered same or similar.
KV says, can a person with a GCEAD form an LLC to use it for owning rental properties? And will that have any impact on the green card process? So yeah, that GCEAD is unrestricted, so it does allow you to do any type of work. And so as long as you are still having your main job offer for the position that you were sponsored for on your labor and I-140, or if you moved to a new job, as Rebecca was talking about, that's in the same or similar occupation, you still need to have that going on in order to support and continue the I-485 and eventually get the green card approved. But because you have an EAD, you can do any kind of work on the side without impacting your ability to get the green card. Now, using that EAD could impact your non-immigrant status. For example, if you're on H-1B and you decide to, on the side, open up a restaurant and you're there working every day in the restaurant, well, that's a violation of your H-1B status because your H-1B only authorizes you to work for the company that sponsored your H-1B in the job and under the terms and conditions of your approved H-1B. Once you do any work that's not in accordance with that H-1B approval, then you're no longer in H-1B status. Now you're just relying on your adjustment of status, which is still lawful status, but you're using your EAD to work for all of your companies from that point.
Ganesh is asking, what is the situation for someone on J1 converting to H-1B? So for someone in J1 status currently, the main thing you need to ascertain is whether you are subject to the 2-year home residency requirement. If you are not sure, it should indicate on your DS 2019 form or your J1 visa stamp should have a notation that says whether or not you are subject to the 2-year residency requirement. And if you are, then in order to change status, not only to H-1B, but to any status directly in the US, you would need to get a waiver of that residency requirement. And there are kind of about 4 or 5 different bases for those waivers. The more common one is getting a no objection statement from your home country's government, and each country, of course, has their own process for doing that, sometimes with specific ministries in those home countries. So you kind of have to look into all of that. And that waiver process can take several months. So you do need to look into what that process is if you're considering getting a waiver, and plan for enough time to get it done before your J1 expires, before your program expires. Then if you're looking to move on to H-1B, if you've never been in H-1B status in the past, you still have to deal with the lottery, with being cap subject or working for a Cap-Exempt organization. If it's a Cap-Exempt organization that's going to be filing for you, then you at least don't need to deal with the lottery. You just have to get the waiver, and then they can file a change of status application for you. If they are a cap subject employer, then you still have to work with them to get selected in the lottery if you've never been in H-1B status before. So yeah, there are kind of a lot of things that need to line up to do a J1 to H-1B conversion. So it's recommended to kind of plan that earlier on in the process.
Prudby says USCIS spoke about new rules to bolster the registration process. What can they actually do without legislation? Can they make new rules for the next season without legislation? So yeah, it's definitely a good point. What can the agency do versus what does Congress need to do? So we know that only Congress can raise the H-1B cap or lower the H-1B cap. Only Congress really can change the timing of the cap, because the statute specifically says these 85,000 visas become available only on October 1st, and you can only file 180 days in advance of the requested start date. But as far as the registration process, I mean, they can go back to the old system and require paper filing. Not that I'm a super big fan of that, because it's very a lot of work that has to be done in a very short period of time. But we didn't have nearly these issues with that process, because when the company had to file a paper petition, they had to include the filing fee checks. And so if that petition got selected, those checks were immediately cashed. So if a company was really only, filing extra petitions and they all ended up getting selected, they're going to be out all of those filing fees, which are, $2,000 to $4,000 for each petition. So if we don't go back to the paper-based filing method, one thing that I think Raul and I talked before is require the company to put the filing fees in escrow, kind of to do the same thing, so that immediately when they're selected, those filing fees are taken by the government for all of their selected cases, not just the ones they pick and choose that they want to file. I think that would help. As far as I've seen so far, kind of the only thing USCIS has proposed is just increasing the registration fee to $215 instead of the $10. I think that's going to have zero impact. Companies that are doing this are just going to pass that cost on to the employees that they're registering, which is not legal, but they still are going to do it. So they're not losing any money by doing that. I've not seen any proposals or anything else that they are talking about doing. They could have kind of a pre-registration, or like a I don't know what you want to call it, kind of a process where a company has to be approved first before they can submit cases in the lottery. But I think that would just slow everything down, because how long does it take to get this pre-approval, and what all do you have to provide for that? I'm sure there's a way that people could get around those rules too. So yeah, I don't know what the solution is. I don't see Congress really doing anything. I think they're leaving it in the hands of USCIS to figure something out. Obviously, one of the easier methods would be, hey, don't allow multiple registrations for one person. That person has to pick one, and only one. And if they get selected, great. If they don't have other choices. That would probably be the easiest thing to do. That's been kind of discussed before, and it kind of bumps up against the statute, because the statute makes it clear that a beneficiary can have multiple H-1B approvals, and only one has to be counted in the cap. So I don't know how you would align that with a requirement that you can only have one registration. And then other people, let the beneficiaries be the one to register, take it out of the company's hands. And then if I get selected, I can go to any company and have them sponsor. I'm not a big fan of that. I think that would even make way more people register, because there's no vetting of, do you even have a bachelor's degree? Do you have a degree in the field that a company is needing? How would you prove that that person has a specialty occupation if they don't even have a job offer yet? So I don't think that's the solution either. I don't know what the solution is, and I don't know what USCIS is planning, but I know just a slight increase in fees is not going to be enough.
Muda is asking about the stateside visa renewal pilot program and when it is expected to be implemented. The last that we've heard, which was the update from the State Department at the annual AILA conference in June, was that they expect it to be implemented by the end of this year. And they did confirm that they expect that the pilot program would be for H&L visa renewals. So end of this year is the most specific that they've gotten, but there is no official announcement yet on exact dates or who will be eligible for it.
Abby wants to know, what are the chances of Department of State making all the dates current in October based on the filing dates chart according to this letter from Raja Krishnamurthy's office? The good thing with it is there's 56 people that signed on to the letter, so there's definitely some, support for it. It's bipartisan, so we have Republicans, we have Democrats in support of it. I think the other side of the coin is, does USCIS have the capability to accept that many filings in 1 month? At least in the first year, they try to make that an option. And then what would they do with all of these EAD and AP renewals that they have to do indefinitely at no additional fee? So I don't know. I think it's maybe 10% chance of going through. I just feel like there's a lot of difficulties involved with it, and it still doesn't fix the problem. I think it's probably going to create more problems. Again, I'm not opposed to it. I'm not telling people don't do it. So don't get me wrong. I just have my doubts that it's going to be workable. But it's definitely an interesting idea. I'd really like to see them stop counting dependents, because I do think that is something that the Biden administration can do. It doesn't require Congress. It's already in line with the statute. That would practically triple the number of green cards available, and at least is less likely to be shot down by court, because again, anything that Biden administration does, you have these anti-immigrant groups that are going to sue and say you don't have the authority to do that. And they might kind of be right here. Does he really have the authority to accept 700,000 adjustment of status applications when there's only 140,000 visas immediately available on October 1st? I don't think so. I don't think that's what they mean by immediately available. At the same time, there is no definition of immediately available in the statute. So maybe they can reinterpret it. I don't know if I just feel like there's a lot of ways that it could turn out to not work, if that makes sense.
Right. Let's see. Okay, so Anna has her 6 years H-1B is expiring at the end of September, and her PERM is filed in December and is still pending. And what are her options? Does she need to leave the U.S.? So one thing I would definitely look at is whether you have any time that you've spent outside the U.S. since you first started H-1B status, Anna. If you have, add up that time. If it adds up to at least 3 months, then if your company is willing to, they can file kind of a short-term extension. If it basically gets you past the 1 year mark of your PERM filing date, they can request a 1 year extension, plus those 3 or 4 months, however much time you've spent outside the US. So it wouldn't be a full 3 year extension, but it would at least get you an extension until probably December 2024 H4. And by then your PERM should be approved, and hopefully if there's no audit and your I-140 can be approved, and you can then the next extension your company files could be for the full 3 years. If your September date for the end of your 6 years already takes into account any travel time and recaptured time that you've spent outside the US, one option, if you don't want to depart the US, is to file for a change of status to H4 if that is available to you, or B2, which is wouldn't allow you to work. Of course, you would be in the US temporarily unable to work, but it would prevent you from having to relocate outside the US for a certain amount of time. And then when your I-140 is approved, the company could file an H-1B change of status from B2 or H4 back to H-1B for you. And one of the good things that USCIS has changed in their policies recently is that they will concurrently process that pending I-539 application and the H-1B application at the same time. Whereas in the past, they used to not touch the H-1B change of status until that I-539 had finished processing, which if there's no premium processing, it could take, 8 months or something like that. So those are kind of your options for remaining in the US if it doesn't work out for your PERM to get approved in time.
David said, what is the difference between priority dates and dates of filing? My priority date is June 2023. When will I be able to file the 485? The lawyer says my priority date is current. So your priority date, if you filed a labor certification, is the day your labor certification was filed with the Department of Labor. Then you take that labor certification and file the I-140 petition, and your I-140 approval notice will have that same priority date mentioned on it. If you did not file a labor certification because you're either EB1 or EB2 NIW or Schedule A, then your priority date is the day that you filed your I-140 petition. So either way, it's kind of the day you started the process that puts you in line. Now, when a priority date becomes current depends on the cutoff dates listed in each month's visa bulletin. So if you're saying my date is current in the month of August, that means you've looked at the August visa bulletin, you've looked at your country of birth, and you've looked at your category, and the cutoff date that is listed there is after your priority date. If that's the case, that means your date is current and you are eligible to file the I-485 application. Now on top of that, it gets even more confusing because there are 2 charts in that visa bulletin. One chart is the date for filing chart, one chart is the final action date chart. And which chart you look at to determine whether you can file your 485 depends on a different chart that USCIS puts out every month. They tell us who can use the filing date chart and who can use the final action date chart. So right now for employment based in the month of August, I believe you have to use the final action date chart. So if your date is current in the filing date, but not the final action date, you still can't file. But if USCIS says you can use the filing date, then you can file if your date is current according to that chart. But that other final action date is what determines when you're eligible to actually be approved. Because right now they're saying a green card is immediately available, but it's not quite available yet. It should be by the end of this fiscal year. Therefore, we're going to accept your application, but we're going to hold it until a green card actually becomes available under the final action date. Then they can finally approve it.
There's a question for someone whose PERM has been pending since September 2022, and when we expect that would be approved. I believe the last time we checked, PERM approvals are coming in for those filed in September. I don't know where exactly in the month they are, but I know our office has been getting PERM approvals for cases filed in September, so I would hope if yours isn't audited that the approval should be coming in any day. So processing times for the PERM are at about 10 months. I think this question also asks, why is it taking so long? I mean, it's kind of a long history. I mean, going back to the Trump administration, kind of in the last months of the Trump administration, they took some actions to basically try to hike up prevailing wages. And that turned out to be struck down by a court. But for the short period of time that those prevailing wages were in effect, it kind of already wreaked a lot of havoc. It put a lot of resources from DOL into dealing with those higher prevailing wages. Then the reversal of it really put the agency back a lot. And then into the pandemic, they said that they got very backlogged during the pandemic, and it has just continued to compound. On top of that, this summer, the agency rolled out a new version of the PERM form that has been full of technical glitches. And that we seem to discover a new technical glitch almost every other day. So that is probably going to affect processing times going forward. I mean, right now it's at 10 months, but that could increase. We have just been seeing the processing times increase over, the past 2 or 3 years. So unfortunately, that's where we are with the DOL processing times. Also, why our partners, Stephen, Brown, and Crystal, are looking into PERM litigation options to address the PERM delays.
Yeah, speaking of that, Thursday evening at 9:00 Eastern time, they are having a call on that exact topic for anyone who's interested and might want to be part of that litigation. So I'm sure we have the information posted somewhere. You can check our website, or if you want more information, you can always reach out to Stephen Brown, Stephen@rnlawgroup.com, and he'll set you up with the details so you can join that call and consider whether you might want to join that litigation. Arun says that he received a 221G in February from the Hyderabad consulate for his H-1B stamping, and then 5 months later he got a denial of the visa and wants to know what are the next steps. It really depends on the reason for the denial. There are some denials where it's based on something that makes you personally ineligible, like if you have prior immigration violations or health ground or criminal ground. Those are called inadmissibilities, meaning you're inadmissible. You cannot be admitted into the U.S. because of these grounds. So then you have to look at, is there a waiver available? And if there is a waiver available, that has to be filed with the recommendation of the consulate. And then that can take many, many months. But if it's successful, then they will waive that ground of inadmissibility so that you can still receive the visa and come into the U.S. and continue your H-1B status. Now, there's another potential ground for denial of the visa, and that's if the consular officer feels that information provided in the petition, the H-1B petition that was filed with USCIS, does not line up with the information that they received during the visa interview at the consulate. Maybe they think that there's something fraudulent or misrepresentation made in the petition that was filed by the company. If that's the situation, then it has nothing to do with you, but you get denied the visa because of it. But what they will do is actually send that petition back to USCIS recommending that it should be revoked. And then USCIS will review that recommendation and actually send a notice of intent to revoke to the company, explaining what the consular officer found and the reasons why they think that the petition should not have been approved in the first place. The company then gets 30 days to respond to it. And then if they successfully respond and are able to overcome the issue, maybe there's a misunderstanding, maybe the consular officer didn't understand something properly, USCIS can then reapprove the petition. Then it goes back to the consulate for your visa to be issued. But if USCIS revokes the petition based on the response of the company, if they find that it should never have been approved in the first place, then there's not really any option for you to receive the visa based on that company's petition. And then depending on the reason for the revocation, if that's the CAP case, your very first initial CAP case, that's revoked due to fraud or misrepresentation, then USCIS could say that you're no longer considered counted in the CAP. You have to go through the lottery again with the new employer. So it's just a lot of things that can happen from that. So definitely consult with an immigration attorney to understand what happened at the interview why it was revoked, and wait to see what USCIS sends when they finally send that notice, which could be months from now. Well, gosh, looks like we're out of time already. Thank you all for joining us. As I mentioned, stay tuned for Thursday evening, 9 o'clock Eastern time. We'll be having a call on the PERM litigation options. Otherwise, we will be back next Tuesday for our regular live.